Hello, my name's Charles Parselle. Welcome to the Legal File. It's a very great pleasure for me today to welcome as my guest a most distinguished Los Angeles attorney, James DeSimone.
Pleasure to see you again, Charles. How are you?
It's nice to see you, James. Thanks for coming on the show. Appreciate it very much. So let's start. We won't start at birth, but let's start with who you are and how you got into this business.
Sure. Well, it's almost from birth. I was born in Brooklyn, New York, and when I was in about first grade, we moved to New Jersey, and that was a big move. Moving from Brooklyn to New Jersey was like moving to the country, even though a lot of people don't think of New Jersey as the country. And my parents took me to a law office, and it was a beautiful little office in the middle of a small town, and I was very impressed with the hardwood floors and the attorney's demeanor, and he was very kind, and I saw what he did, and I said, "Did that lawyer just get paid to do what he just did?" My parents said, "Yeah." I said, "I can do that." And so from first grade on, I had in my mind that I wanted to be a lawyer, and in some ways dedicated myself to achieve that.
How interesting. Did you go to law school back east?
I didn't. I graduated from Johns Hopkins University in 1981, and then kind of had the travel bug and came across the country west and ended up at UCLA, where I graduated in 1985.
You graduated from law school there?
Yes, sir.
Sat at the California bar?
Absolutely, and wasn't quite sure what I wanted to do, and I'll tell you why. I mean, I went to law school because I thought it was a noble profession. I still think it's a noble profession, something where you can use the law not just to make money, but to benefit people. And those avenues were not so readily apparent. What you have in law school is a lot of corporate law firms interviewing students. You don't necessarily see the avenues that you could take the law and both make a living at it and benefit common people. So it took me a little while to find my niche in the law.
So your niche to start off with was where?
I worked for a downtown law firm, a small law firm, doing some white-collar criminal defense work, then ended up working for a number of different lawyers. But I really found my calling at a legal services agency at Westside Legal Services in Santa Monica, representing lower-income individuals and families for 3 years. I met some fabulous attorneys doing it who were volunteering there, and to help people. Was making about as much as my low-income clients during the period of time, and was fortunate enough to meet a gentleman by the name of Benjamin Schoenbrunn, who he and I became partners some years later in 1990, and we're still together now.
Now, I've heard that you are perhaps the only firm that has a law practice right on the beach. Is that right?
Well, it's right that we're on the beach. There's a couple of other law firms there, but we are fortunate enough to have this amazing conference room that overlooks the ocean there in Venice Beach. I mean, I know a lot of people have heard of Venice, and it's a place that has a very unique character in Southern California. So we practice a very interesting, vibrant areas of the law in a beautiful, vibrant place called Venice, California.
What areas of the law do you practice in?
Well, I'm a civil rights lawyer, and our firm is composed of civil rights and human rights lawyers. We do some international human rights work, and civil rights law is really an area where you're protecting the civil rights of individuals in court, such as someone has been discriminated against, someone's been injured by a product, someone's been injured by the police or a government entity. We protect people, and we come into court to vindicate their rights and do our best to accomplish that.
Now, do all these people have to have enough money to pay you?
No, not at all. And the beauty of what we call the contingency fee system is that it really enables your average individual who, let's face it, I've been a lawyer for 23 years now. $500, $600 an hour would be what I would be charging if I worked for one of those corporate law firms that I could have gotten a job with out of law school. Even more, sometimes $800 to $1,000 an hour. An average person can't afford that type of lawyer. What the contingency fee system does is it levels the playing field. It allows an ordinary person like you, like me, like our parents, our children, to obtain a lawyer in a situation where they need a lawyer to fight for their rights.
Well, what is you say a contingency fee system, what does that actually mean?
Well, it can mean a couple of things. I mean, lawsuits can be expensive to prosecute. Someone has to pay those costs. I mean, it could range anywhere from $5,000 to $150,000 that someone has to pay out of pocket in terms of court costs, hiring experts, paying deposition fees, and so on. There are times when the individual will contribute towards paying those costs. But in a situation where a person can't afford those costs, firms like mine are willing to risk in some ways, because you can lose these cases, and to invest our own money to prosecute those cases on behalf of those individuals. As a result, at the end of the case, we take a percentage. Anywhere from 33 to 40% is a normal contingency fee, and that both compensates us for the work that we do and also for the risk of the money that we're risking, as well as the fact that we may just be risking our time and not get anything at all, which you know, occurs rarely, but it does occur.
So if you lose the case, the client doesn't recover, but also is not out of pocket. Is that how it works?
That's how it works. Now, don't get me wrong, and people have a conception that if you file a lawsuit, you're not at risk. If someone takes a case to trial and loses a case, they get a monetary judgment against them. And oftentimes, what it means is the defendant in a case, even if it's the largest corporation in the world, can have a judgment against John Doe for X amount of money. So it's not as if undertaking a lawsuit is without any risks, even if you find an attorney like me or the other lawyers in my firm to take a case on a contingency fee. What we try to do is analyze cases carefully and make sure that we don't put our clients at risk. And if we're going to take a case to trial, it's a case that we believe in. It's a case that we think that we can win. And in the small number of cases we've lost, we have been able to protect our clients so they don't end up with that kind of judgment against them.
Do you find that you have to reject many cases?
98% of people who write to us or call us are cases we don't take on. Simply because either we don't think the case is meritorious enough, or that the amount of work that we'd have to put in doesn't justify our involvement. And that doesn't mean that they don't necessarily that they don't have a case. And sometimes if we think that they have a case, but we're just not the right fit for them as a firm, we'll try to get them into good hands.
Do you think if an attorney rejects a case, is that the end of the road for the client, or would that person have better luck, possibly elsewhere?
I think a person should definitely, even if the first attorney rejects a case, to try several lawyers. Maybe that attorney doesn't practice that area of the law. Maybe they're very busy. But there are a lot of lawyers out there, and there's a lot of good, dedicated lawyers out there, and it makes sense to try to find another lawyer. If you go through several tries and you're finding lawyers that practice the area of the law that you're looking for, maybe it's just not a case that ought to be pursued.
Now, I know you for a high-profile attorney. You've acquired that reputation along the road. Will you tell us about some of the high-profile cases you've handled? Or perhaps start at the beginning. How did you get this reputation in the first place?
Well, it's funny. When I joined Ben Schoenbrunn, we were a small firm. It was he and I at this small office on Venice Beach. Basically a personal injury firm. I felt that Ben had great promise, and we really wanted to do something special in the law and make a difference. And we were dedicated to make a difference. And sometimes good fortune in terms of who contacts you is getting the right client. And I was sitting late in the office one evening, and a woman by the name of Penny Muck called the office, and she said, "I work for David Geffen Company Records. I work for the president." And I was sitting at my desk 2 days ago, and the president of the company came up, and he took out his penis, and he put it in my ear. And I was shocked, and she started to giggle a little bit. And my first reaction, Charles, was that, is this a joke? Is someone pranking us? Because this couldn't possibly happen. At that point, Nirvana had just come out. David Geffen is one of the most well-known record companies, and it just seemed that wouldn't happen in the workplace. It would be, that type of conduct just wouldn't occur. But it turned out to be true. We were able to prove that it was true because he actually, if masturbated, and she had the evidence. He masturbated on a magazine, wasn't aware of DNA, wiped it clean, threw it into a garbage can, and she took it. We had it secured and tested, and the case resolved favorably. What that did for my firm was we litigated that case in a vigorous manner. They wanted to settle it early. We wanted to bring it to the public eye. We were on the front page of the Los Angeles Times. We were on the news show Prime Time. We took David Geffen's deposition personally. And really, we were up against Bert Fields, a well-known entertainment lawyer who claims never to have lost a case. And the reason why he can claim never to have lost a case is because he settles cases like the Muck versus Geffen Records case.
Right. Now, there's also what are known as police abuse cases. Have you got into that field?
Well, it was ironic. At the same time, a woman called us who was the sister of a client of mine at Westside Legal Services who came in because she had a hair burn from a perm at Vidal Sassoon, and Ben had picked up the client, and it was a case, it was worth a few $1,000s, and I had litigated it through an arbitration. Well, her son was mentally ill, and they had taken him to UCLA Hospital. Her son's name was Terrence Williams, and he had gotten out of the hospital and went home, took a shower, and was confronted by a couple of Hawthorne police officers. And an altercation developed. And they basically assassinated him. They chased him into an alley. He had his hands outstretched, and there was an eyewitness, no video, but an eyewitness who verified this, and he said to the officer, "What are you going to do now? Shoot me." And horrifically, this officer came up and shot 7 bullets into him and killed him that day. And that was our first police misconduct case. I remember talking to Ben, "Are we ready for this?" And he said, "Yes, we're ready for this." And we litigated that case into federal court. We litigated up into the time of trial, and we resolved that case for $1 million in 1991.
So that got you into the police abuse arena and
Absolutely.
the civil rights arena. What are you looking for when you have to make the determination whether to take a case or no?
I'm glad you asked, because there's a few things that go into it. I mean, first of all, you have to have someone who was wronged. I mean, there has to be some sort of sense that there was an injustice here, and an injustice that needs to be turned around. I mean, we can't unring the bell. We couldn't bring Terrence Williams back to life, but the family, when they were compensated, received a sense of justice, that at least someone heard them, that what happened to their son was wrong. I mean, the second thing, quite frankly, is you have to have someone on the other end who could compensate the person who is wronged. Without that, financially, it's just not viable to prosecute a case. The third thing is what I call the likability factor. I mean, if a client is absolutely an unreasonable and unlikable person, I oftentimes want them to find another lawyer, because I'm a pretty liberal judge of character. You know, I'm here on Venice Beach. I'm friends with the tattoo artists, the people, you know, selling the items on the beach. I mean, I feel that I'm a man of the people and can relate to almost anyone on one level or another. So if I'm sitting across the table and I don't like this person, well, how am I going to come into court and have a jury of 12 people who, most of whom don't really want to be there, like my client? And oftentimes, juries are not going to compensate a person unless there's that likability factor. So there is that in play, that I want to have a rapport with the client, have someone who I feel is deserving of having us represent them and obtain justice on their behalf.
You said that people, well, you were talking in particular about the Williams case, that clients really value obtaining that sense of justice. Now, then there's also the money. So how much is it the sense of justice, and how much is it the money, if you can disentangle them?
Well, in our civil justice system, what really plays a role in it is our system is based on monetary compensation. We prosecute cases, but we prosecute cases in a civil arena. When we prosecute cases, we can't send someone to jail for their wrongdoing. That's up to a district attorney and a city attorney. They have the power of the state. We don't have the power of the state. But what we can do as civil attorneys is obtain monetary compensation. And oftentimes, by obtaining monetary compensation, you provide an incentive to police agencies, to companies, not to engage in that wrongdoing again. I mean, you hit them hard enough in their pocketbook, and they're going to change their policies. And I'll give you an example, and one example is the Los Angeles Police Department. When I was first a civil rights lawyer in the early 90s, you had a situation where the Los Angeles Police Department were using their police dogs to basically torture people, to bite their legs, chew off gaps of their legs, different parts of their body, if they thought that that person had mouthed off to them, had run away from them, or something like that. I mean, the person may deserve to be arrested, but these dogs could do quite a bit of damage. I mean, some of them were pit bulls, German shepherds. And the overwhelming majority of people to whom that was done were African Americans, Latinos, and other minorities. So you really had a disproportionate use of 90% of the people who those dogs were used against were the minorities of our community, although they actually play a predominant role in our community, of course. It was only through the efforts of lawyers getting together and putting these together in a statistical fashion that the Los Angeles Police Department changed its policy and went from a find and bite policy to a find and bark policy. And you just don't have that type of use of police dogs anymore to injure and maim individuals on the street. And that shows how if you have a civil lawsuit, you can get government entities and companies to change their practices to the benefit of all of us.
Have you seen over the years much change arising out of the very great increased use of cell phone cameras, small video cameras, that sort of thing?
Well, you know, it's funny. I think everybody expects that if you're going to have a trial now, you're going to have a video. and it doesn't always work that way. In fact, in one of my recent cases, there was a video, and the company, quote unquote, lost the video of the underlying incident. This was a supermarket case. I do think that there's a self-censorship impact of videos where maybe people become on their better behavior. But on the other hand, I do think that when people are in that moment, they don't necessarily think that they're going to be on video, and I think it's a great use of evidence when you have it in a case in order to prove what really happened.
Lawyers today, I would say, over the last several years, have for some reason have acquired a poor reputation in the society at large. Would you care to comment on that?
Well, sure. And, you know, and I think that, look, lawyers are like any other profession. There are the good and the bad. I think that the poor reputations of lawyers across the board is a bit unfair. For instance, there's some misperceptions. People assume that all lawyers are rich. I mean, I make a decent living at what I do. I'm nowhere near rich. You know, that's for certain, even though I've been toiling at it for a number of years. We work very hard in our profession. I work 16-hour days, you know, more often than I would like to. I'm not a workaholic. I have a family. I have children. I'd rather be doing things with them than being on my computer. I think that it's unfair. It's sort of like the police. I mean, sometimes the police have bad reputation until you need them. You know, if somebody's robbing your house, you want police officers who come in, who are competent and professional. I sue the police, but I have a great deal of respect for police and have called them on occasion. Well, it's the same thing with lawyers. They have a bad reputation until you've been wronged. And once you're in a situation, if God forbid someone gets badly injured, gets their rights violated, finding a good, ethical, dedicated lawyer is paramount and very, very important. So I think that while our profession as a whole has a bad reputation, for some reason, and maybe that's a little overstated, but you know, we can all take a joke, and lawyer jokes are fine. I do think it's unfair because it's, you know, what is our country based on? Our country is based on the Constitution of the United States. We're civil rights lawyers. We uphold that Constitution. I mean, when you talk about what America is about, our system of justice is one of the most important elements of what makes America great. And as lawyers, we're just part of that system for the country that we all love.
If you're out there, you're a member of the public, use the expression, if you need a lawyer, you need a dedicated professional. A good lawyer. How is a member of the public going to find such an attorney?
Well, you know, it's a wonderful time in some ways to live in because of the amount of information that one could access at one's fingertips. You know, there's the old saying, let your fingers do the walking through the yellow pages. Well, there you'd have a yellow page ad and a, you know, a two-dimensional object in terms of a lawyer's name and who to call. Well, now we have the internet. And you can do Google searches, and you could search for different lawyers. And lawyers who have a good track record will put that track record on their website. I mean, we have a website, for instance, at civilrightslawla.com and LosAngelesEmploymentLawyer.com for people who are doing certain searches to find us, and they could look at what we've done, they could look at what other lawyers have done in the community, and then make that choice for themselves as who would be the right fit for them.
Do you find as an attorney that belonging to lawyer organizations is a help to you, and what kind of organizations do you belong to?
Well, first of all, it's an incredible help because it's a way in which to share resources, to meet like-minded people. I belong to a number of different groups, but most prominent, the Consumer Attorneys Association of Los Angeles. Individuals like myself who are dedicated to assist consumers when they've been wronged by others. I also belong to the California Employment Lawyers Association and the National Employment Lawyers Association, and these groups are dedicated to assist employees when they have trouble in the workplace. And it's just we do lobbying to try to pass laws that are beneficial for all of us as consumers and employees. And we also, you know, we don't work for big companies. We're mainly, you know, solo practitioners, small law firms. I mean, my law firm is considered a big law firm, and what we do, we've got 10 lawyers. But really, I mean, in the grand scheme of things, when you're compared to the people who we're up against, they always have superior firepower. I mean, you know, you're dealing with corporate law firms who have hundreds and hundreds of lawyers. So to share those resources is of great benefit.
Well, we already talked about, and I expressed it in the negative, poor reputation that lawyers have, unfortunately, among much of the general public. But do you think much of that, or some of it anyway, is based on misperceptions among the public about lawyers?
I really do. I mean, when people talk about tort reform, for instance, it really is a way to restrict their access, the public's access, to lawyers like myself who, you know, represent the poorest of the poor, middle class, I mean, even some upper class people, but in a way that they're not paying thousands and thousands of dollars a month to retain my services or my law firm services. Nobody ever talks about restricting, when tort reform, restricting corporations from paying as much money as they want to pay to fight against your common person. And in a way, it's almost like the notion of tort reform shoots the average person in the foot because it could restrict their access to lawyers if, for instance, the contingency fee system was changed in a way that restricted our right to have a contingency fee. It also goes against the grain of the free enterprise system. I mean, our country, our capitalist system is predicated on somebody being able to go out and negotiate the wage they can, and the contingency fee system is precisely that. You negotiate something for a percentage of what you can get in the end, and it really is, in a way, a beautiful harmonic system that works for your average person.
Do you feel, though, that some limits need to be placed on lawyers?
Well, I think those limits are in place. I mean, you already have laws that prohibit frivolous lawsuits. You already have laws that a lawyer who files a certain number of frivolous lawsuits can no longer be able to file such lawsuits. It's called the vexatious litigant law. So, yes, there should be limits placed, and both the state bar and the state of California does properly place those limits. And quite frankly, I don't think that additional limits need to be placed.
Right. We don't have too much time, but I really would like to hear a little bit about the Mogilevsky case.
Well, Mogilevsky was a same-sex harassment case, and it came out of the Penny Mug case. And what it did was, it's the first case that established that same-sex harassment. Wayne Mogilevsky was a screenwriter for Silver Pictures and was asked on Valentine's Day to come to a hotel suite of the president of Silver Pictures and asked to spend the night with him, and then there were certain other things were asked of him to do. And he was promised a better deal if he did them. We were thrown out of court. The first judge said it's not a sex harassment case, and we appealed, and once again we were against Bert Fields and Howard Weitzman, and it's a published decision in which it established that no matter if the victim or the person who is basically harassing someone is a male or a female on a female, it violates the law. It depends on what the conduct is. And if the conduct is sex harassment, it violates the laws against sex harassment. And we were very honored to set the precedent of that in 1992, a case called Mogilevsky versus Silver Pictures.
So how has your life changed from, 20 years ago you were young, raw, green. Now here you are, high-profile attorney with some major decisions that have changed California law behind you. How has things changed for you?
I just work harder. I didn't know it would work out that way, but we believe in what we do. I feel gratified to take on cases that I believe in to assist the clients that we do. And I try to have a good balance of working hard and playing hard still. But we work hard on behalf of our clients, and it's a pleasure doing that.
Finally, we're almost there, but in half a minute, how do you see juries nowadays, and how do you see jury verdicts?
Well, it's a lot harder to win cases now, and I think what really is occurring is people have developed a very cynical view towards lawsuits, and a lot of what we have to do is we're fighting more of an uphill battle here in California. There's a bigger distrust of lawyers and a bigger distrust of the individuals who bring lawsuits. That being said, there's still marvelous victories in terms of the rights of consumers, and I wish that those people who serve on juries realize that the individuals who get to court, who are in court that day and trying to obtain justice, are people just like you and me, just like the 12 people who are sitting there on the jury, and give them a fair shake, and that if their case is meritorious, to give them a just verdict.
Well, what I get out of talking to you is that you're a composed man, a rational man, but underneath that, a man of great passion. And your life story certainly has shown it. It has been a great pleasure today to talk to attorney James DeSimone, Venice, California. Thank you so much for coming. Hope we can see more of you in the future.
Thank you very much.
Oh, it's been a pleasure. Now we just talk and we just chat.